Welcome once again to Lehto's Law. Here's Steve Lehto.
I've done a few videos about AI being misused by people, including attorneys, and it kind of got to the point where attorneys misusing AI was no longer news. In fact, the stories all started to sound alike. And then Yvette sent me a note and said, Steve, check out this story about attorneys misusing AI. And I thought to myself, haven't we already done this before? But then again, would Yvette steer me wrong? Maybe not. Let's take a look at it. And I read the case and I'm like, whoa. This is an interesting story because in this instance, an attorney appears to have lost the plot, for lack of a better phrase, because when it's pointed out that AI was misused, AI continued to be misused. And, So this is a real case, and I'm putting that there because I think it's necessary. This is a real case out of Georgia. Shahid versus Assam. It's a divorce case. So we'll talk about husband and wife. After the trial court entered a final judgment and decree of divorce, the wife filed a petition to reopen the case and set aside the final judgment, arguing that service by publication was improper. So at its very, very most simple terms, the case started out because man files to divorce his wife, and instead of serving her personally with a summons and complaint, they served her by publication. They published notices that she was expected to see somehow. And that would work back in the old days. You go down to the town square and you publish a notice, hey, so-and-so is suing so-and-so. Word would get around in the community and, hey, you're being sued. Oh, I guess I better go read that notice. But publication these days doesn't exactly get the right people. So the trial court denied the wife's motion to set aside the divorce decree, and they used an order, the trial court did, used an order that relied upon non-existent case law. For the reasons we discussed below, we vacate the order and remand for the trial court to hold a new hearing on the wife's petition. We also levy a frivolous motion penalty against the attorney for the husband. And now, some people have already caught something. A lower court made a mistake because the lower court also relied upon bad case law. And so when an attorney submits bad case law to a court, the court should have somebody checking the case law to make sure it makes sense, especially if it's cases they're not familiar with, which it would be because they were invented by AI. But according to the wife's October 2023 verified petition to open the case, husband filed a complaint for divorce in April of 22. Service was performed by publication, and the trial court entered a final judgment in July of 2022. In the petition, wife argued that she had moved to Texas after they had separated and that husband failed to use reasonable diligence to figure out where she was. Instead, they notified her by publication. Following a hearing, the Supreme Court denied wife's motion, and here the Court of Appeals has granted the wife's application for discretionary review, and the appeal followed. Now, the wife argues, and she cites a case, that the Superior Court made a mistake when it denied her petition to reopen the case and set aside the divorce decree because husband did not make a sufficient showing of due diligence to allow service by publication under the Georgia statutes. Wife points out in her brief that the trial court also relied on two fictitious cases in its order denying her petition, and she argues that the order is therefore void on its face. Now, in the husband's brief, which is filed by his attorney, it doesn't address the wife's assertion that the order relied on bogus case law. But his attorney relies instead on 4 cases, 2 of which appear to be fictitious, and the other 2 have nothing to do with the proposition stated in the brief. And I know many attorneys who've toyed with these things. A very good friend of mine said he asked one of these programs to draft him a brief. And he goes, it's the most beautifully written thing I've ever seen. And he goes, then I started looking at the cases, and it turns out that half the cases didn't exist, and half the cases that did exist didn't say what they're alleged to have said in the brief. So it creates all this meaningless stuff. So undeterred by wife's argument that the order is void in its face because it relies on non-existent cases, husband cites 11 additional citations in response that are either hallucinated or have nothing to do with the propositions for which they're cited. The brief further adds insult to injury by requesting attorney fees on appeal and supports the request with a hallucinated case. So, that's not good. So the court says we are troubled by the citation of bogus cases in the trial court's order. As the reviewing court, we make no findings of fact as to how this impropriety occurred, observing only that the order purports to have been prepared by the attorney for the husband. And that's not uncommon. When someone comes into court, they'll prepare an order and say, Your Honor, we want you to enter this order. Judge doesn't have to, but if the order says what the judge wants it to say, the judge will often enter it and sign it and so on. So we further note that the attorney had cited the 2 fictitious cases that made it into the trial court's order in husband's response to the petition to reopen. And she cited additional fake cases both in that response and in the brief filed in this court. As noted above, the irregularities in these filings suggest they were drafted using generative AI. Chief Justice John Roberts of SCOTUS warned that any use of AI requires caution and humility. He specifically noted that commonly used AI applications can be prone to hallucination, which causes lawyers using those programs to submit briefs with citations to non-existent cases. Although the present case may be the first occasion for a Georgia appellate court to confront the problems that can flow from this, other courts have commented on the issue, including in federal cases. Indeed, many harms flow from the submission of fake opinions. The opposing party wastes time and money in exposing it. The court's time is taken from other important endeavors. The client may be deprived of arguments based on authentic precedent. There's potential harm to the reputation of judges and courts whose names are falsely invoked as authors of bogus opinions, and to the reputation of a party attributed to fictional conduct. It promotes cynicism about the legal profession and the American judicial system, and a future litigant may be tempted to defy a judicial ruling by disingenuously claiming doubt about its authenticity. And so it goes on and on. But the scary part here is that at one point in time, the court writes, well, first of all, the court vacates the order, sends it back down, and says, straighten this mess out. But there's an appendix to the opinion. The following is a list of fictitious cases included in appellee's brief. And there's 1, 2, 3, 4, 5, 6, 7 of them. These are fictitious cases. In the interest of JMB, from 2009, I remember that one. Miller versus State, Brown versus State, Walker versus Georgia, Ramos versus Ramos. That sounds like it could have been a divorce case. McRae versus McRae, and Johnson versus Johnson. That was a barn burner. Appellee's brief also contained 4 citations to real cases that have nothing to do with the propositions for which they are used. And it cites those 4 cases. And then, as noted previously, the attorney for the wife actually said, we should get our attorney fees for this because we shouldn't have to respond to this kind of silly nonsense. The court's like, what are you talking about? You're the one who served somebody improperly because it turns out there was no case law supporting what they had done. Then you submitted fake cases to support your position. And when that got called out, you cited even more fake cases to support your use of fake cases, to the point where a court actually incorporated some of your fake cases into its ruling. And I actually have had several viewers of mine in the last few months predict this. I had at least 2 different people contact me and say, Steve, how much do you want to bet that you're going to get a situation where a court cites a fake citation because nobody else caught it? And once they cite it, then it sort of becomes quasi-real, doesn't it? No. If a case was reported and contained fake citations, that might cause a problem. Of course, they can always go back and amend these things. But this right here is a great example. And so the case started on the wrong foot because they served somebody by publication in a manner which was inappropriate at the time. And so when the wife comes in with her attorney and says, hey, look, that's incorrect. And, oh, by the way, the order contains fictitious citations. The court doesn't correct it, and it winds up coming up on appeal. And more incorrect citations get used in front of this court. And what's even crazier, but it's a little more subtle, is that the court points out there are 4 cases in one section. 2 of them were completely made up. And 2 of them were real cases, but didn't stand for the proposition for which they're cited. And so if somebody said to me, Steve, can you name a case in Michigan that addresses the lemon law and talks about the lemon law? I'd say, yeah, Ayer versus Ford Motor Company, Ayer, Ayer versus Ford. You go, okay. And then they say, have you ever heard of the case of Johnson versus Mitsubishi? No, I haven't. What's it say? If you told me it then said something, and I went and looked the case up, but I can't find it because there is no Johnson versus Mitsubishi with the rest of the citation, I'd say, okay, that sounds like a fictitious case, a hallucinated case. But then if you said, oh, Steve, there's a case called Kellinack. Are you familiar with that case? Yes, I am. Kellinack versus Yamaha. Okay, well, are you aware that Kellinack versus Yamaha says such and such about the lemon law? I go, I don't think it does. It's a motorcycle case. And if it talks about the lemon law, I'd talk about it only in passing because it's not a lemon law case. But if I saw that citation in a brief, I'd have a brief moment of recognition and I go, oh, that is a real case, but does it stand for the proposition for which it's being cited in this particular brief? And that's a problem also. And so I've talked before about how I don't want to be a judge. I do not want to be a judge. I don't want to be a pirate either. And so I don't want to be a judge, but if I was a judge and this happened in front of me, and I got to actually ask an attorney and say, let me get this straight. You prepared a document for this court to sign that contained made-up citations that you didn't even bother to check. Is that what happened here? Because don't tell me you checked them, otherwise you would have caught them. And some people are going to say, but Steve, the stuff is starting to happen. You got to put up with it. I've mentioned before that if you're an attorney and you sign a document, I'm not talking about an autograph. I'm talking about signing a legal document. There actually is an effect that your signature has. And I went and pulled it from Michigan because Michigan court rules I'm very, very familiar with. MCR's 1.109, effect of signature. The signature of a person filing a document, whether or not represented by an attorney, constitutes a certification by the signer that, and so an attorney is a person filing a document. We file tons of documents. That's all we do. It's a certification that you have read the document. Okay? So you can't say, I didn't read it, I just signed it. No. You certified that you read it. 2, to the best of his or her knowledge, information, and belief, formed after reasonable inquiry, the document is well grounded in fact and is warranted by existing law or a good faith argument for the extension, modification, or reversal of existing law. And the document is not interposed for any improper purpose, such as to harass or to cause unnecessary delay or needless increase in cost of litigation. So to sign the documents submitted to the court, like briefs that contain hallucinations, you're certifying that you've read the document, that you've done a reasonable inquiry, and the document is well-founded, the document is well-grounded in fact, and is warranted by existing law or good faith argument for the extension, modification, or reversal of existing law. So you sign this document. Did you read it? Yes. Okay. Where did these citations come from? ChatGPT. Okay, so when you read a document that contains citations you're not familiar with, shouldn't you go check them to be certain that the document is well grounded in fact and is warranted by existing law? How do you know it's warranted by existing law unless you checked existing law and the stuff cited in your brief? And so I assure you that Georgia has a similar statute on their books or a court rule on their books saying specifically that if you sign it, you're an attorney, it's on you. So understand that the very next section says sanctions for violation. If a document's signed in violation of this rule, the court, on the motion of a party or on its own, shall impose upon the person who signed it, a represented party, or both, an appropriate sanction, which may include an order to pay to the other party or parties the amount of the reasonable expenses incurred because of the filing of the document, including reasonable attorney fees. Now, it does say the court may not assess punitive damages. That's sad, because sometimes they should. But then it does say there's also sanctions for frivolous claims and defenses. And in addition to sanctions under this rule, a party pleading a frivolous claim or defense is subject to costs as provided in another subsection here. Again, a party pleading a frivolous claim. And I would argue that the height of frivolity is asserting a claim supported by nothing but AI hallucinations. So it's a crazy case, but Yvette, thank you for passing that along. Yeah, I don't do a lot of AI cases anymore because in my mind they're all starting to sound alike. But here we've got one where a court actually cited hallucinated cases. The Court of Appeals points it out and says there's problems here because even on appeal, the attorney who filed other stuff with problems has now filed more stuff with problems, including there's an appendix full of cases that were hallucinations. So the case is called Shahid versus Assam. Assam is spelled E-S-A-A-M, and the case is handed down June 30th of this year. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. If at first you do not succeed, blame your computer.